Order, item number 1.
Bail.
Bail.
Bail granted, 1 lakh local surety for, 2 local sureties for 1 lakh.
Obliged.
Item number 2.
Yes, granted, same. 1 lakh, 2 local sureties.
Obliged.
And item number 3.
Item 3, yes.
You see that PP may, not PP, prosecution may be assisted, but I'm setting aside only that part of the order where the petition will be considered after evidence. So the petition will be considered afresh by the CJM before evidence, not after evidence. Anytime when you place the petition. Okay, under section 24(8), where whatever time you wish to place the petition, it will be considered. That condition is there to place the petition after the evidence. That condition is not required. To consider the petition after the evidence, that only that part of the order is set aside. Okay. You'll have to place the petition afresh. You'll have to place the petition for assistance afresh. Okay. It will be uploaded, you'll get to know.
Please, Your Lordship.
Yes.
Lordship, I'd like to mention hearing item number 14. Lordship,
Yes.
yeah, and for the petition, my lord, if this matter can be listed after 2 weeks, my lord, my senior has some difficulties to do so. Item number 14.
Learned Counsel, Miss?
Miss Lucino for the petitioner, my lord.
Uh,
Miss Lucino.
Lucino
Yes, my lord.
has prayed for adjournment. With the consent of the other side has prayed for adjournment. List the matter after 2
Two
weeks.
weeks, my lord. And I also beg to mention item number 15. my lord. Not here, we are the newly engaged counsel for the petitioners. So if some time may be granted to me to prepare the brief, my lord, 4 weeks, my lord, if this can be listed after 4 weeks.
Learned Counsel, Miss Lucino, with the consent of the other side has prayed for adjournment. List the petition after 4 weeks.
Yes, ma'am. Obliged.
May it please, Your Lordship, I beg to mention here in item number 13, Your Lordship. I'm appearing on behalf of my senior and Longkumar, Your Lordship, if a week may be granted, since my senior is indisposed.
Learned Counsel, Miss, your name?
Kim Piana,
Kim Pianang, on behalf of Learned Counsel, Mr. N.
Longkumar.
N. Longkumar has prayed for adjournment. Okay. List the matter when do you want?
After a week, Your Lordship.
With the consent of the other side has prayed for adjournment. List the matter after 1 week.
Okay. Much obliged. Maybe, Sir Lordship. Lordship, I'd like to mention item number 12,
12.
Lordship, on behalf of my colleague, Lordship. If this matter can be listed after 3 weeks, Lordship, hearing matter.
Your name?
S. Chang,
Learned Counsel, Ms. S. Chang, on behalf of Learned Government Advocate,
Lordship.
Nagaland, with the consent of the other side,
Lordship,
has
I
prayed
think-
for adjournment. List the matter when do you want?
After 3 weeks, Lordship.
After 3 weeks.
Lordship. Now, I have similar prayer for item number 5 as well, Lordship. 3 weeks to file my affidavit in opposition, Lordship.
একেটা নামে লিখি দিবা, একেবাৰে লিখি দিবা। 3 weeks. Item number 5.
Much obliged, Lordship.
May I please, Your Lordship? My lord, I beg to mention item number 6. My lord, here this morning only I've received the affidavit in reply filed by the petitioner. So kindly let the matter come up on 13 May so that I can file the counter, my lord.
Your Lordship, this is a contractual matter. So my lord, since the work order has already been issued on 16th of January, and this is a project under the PMGSY, road construction work. So my lord, contractual matters, as this honorable court is aware, it's urgent in nature. It has to be disposed of as early as possible. The instruction may be sought. I have no objection to that, but it may kindly be
You have
listed.
received-
My lord?
You have received the work order?
No, Your Lordship, I'm challenging the work order.
You're challenging the work
Yes,
order?
yes, Your Lordship. So it may be listed on coming Tuesday, because this matter has also been dragging on for quite some time now.
Representing respondent number 4, Lordship, I
Last one.
received the affidavit reply filed by petitioner only last night, Lordship. There are some amendments which I need to get instruction from the client, Lordship. If I may be allowed 2 weeks, Lordship.
No. They have the work order. So your lordship, in any case, what I have said is all based on record, nothing outside the record. In fact, even without the affidavit in reply also, it would suffice going by the records, but yes, your lordship. Yes, your lordship. So my lord,
My lord, opportunity may be granted to us to file the counter if necessary. So let the matter be come up on 13 May, my lord.
whether counter will be necessary for for an affidavit, an affidavit or reply affidavit, your lordship.
Possibly in my case, it will be necessary, Lordship. There are some specific amendments, Lordship.
That is based on the record, all in the record, your lordship, nothing outside the record.
That is on the status of the present project, Lordship.
That also on the basis of the record that they have annexed in the affidavit in opposition, your lordship.
Stay has been granted.
There is no stay that is for your lordship. It has to be urgently disposed of,
1 week, 1 week,
February is only 2 weeks.
1 week, 1 week,
my lord.
1 week, okay? Learned Counsel, Mr.
Joshua, your lordship.
Joshua
Shaki,
Sheki, who is present for, Joshua Sheki is present for the petitioners. Learned Counsel, Mr.
ETIPA form for the respondent number 1 to 3.
Your name
State
is
respondent 1 to 3. ETIPA form.
Tiba,
Form.
you're government advocate?
Yes, my lord.
Learned government advocate?
Yes, my lord.
Mr. Tiba
Form
Khon for respondent number 1
1,
to
2, 3.
3 has submitted for time to file counter affidavit.
Yes, no, yes, counter to the affidavit in reply.
Counter
filed by the
affidavit against the affidavit in reply.
Reply, yes, my
my
lord.
lord.
Similar prayer by the respondent.
And Learned Counsel, Mr.
More general, Lordship.
Muaz Jami, for respondent number 4
Lordship.
has also submitted for time to file affidavit in reply. The learned, counter affidavit against the affidavit in reply, the learned counsel, who submitted the learned counsel for the petitioner has raised objection stating that affidavit in reply is not required to be submitted. However, time is allowed to file every affidavit. Oh no, affidavit in counter affidavit is not required. Full stop DD. However, time is allowed to file counter affidavit, list the matter after 1 week.
Yes, my
On
lord.
8, date may be fixed, your lordship. Matter may be fixed on
Okay.
8. That
9
is after
Friday.
1 week. 9 is Friday, your lordship. Today is Thursday, so 1 week is 8. My lord,
8, then 8,
my lord.
8. No, 9 is not Friday. Oh, yeah, Friday.
It's a Friday, your lordship.
Okay, so
My lord,
Friday
8.
you have a.
No, 8. No, Friday, normally court business is cold. So it may, since they are asking for 1 week, after 1 week will be 8, your lordship.
Exactly 8. Okay,
Your lordship.
this is a matter on 8/5.
Obliged, your
Obliged.
lordship.
Please, your lordship.
Lordship, I beg to mention hearing item 9. Lordship, here I am for the respondent number 4. However, Lordship, here the arguing counsel for respondent number 4 is currently out of station.
Hmm.
So may this matter come up on Tuesday.
Okay, learned counsel, Mr.
V. Koza, Lordship.
V.
Koza.
Koza for respondent number 4 has. Your presence is required to be recorded? Not required, okay. It has prayed for time to file, submit what?
No, Lordship, the arguing counsel for
Oh,
respondent 4 is out of
adjournment
station.
on behalf of learned counsel,
Ajo.
Ajo. List the matter, with the consent of the other side, likhi diba de, maza bhai diba. List the matter after how many days?
So on the 6th of May, next week.
Next week, 6th of May,
Tuesday,
okay?
Tuesday.
6th of May.
And Lordship, there's an
6/5.
interim here if it can be
Interim
extended.
order. Is there any interim order?
Yes, my lord, there is
Interim
an
order shall remain in force till then.
obliged. Your Lord.
Much appreciated.
Yeah, please, your lordship.
Yes, yes.
Lordship, I beg to mention item number 10 and 11, lordship.
10 and 11?
10
Yes.
and 11. It was, on the last occasion, the prayer was made to fix it on 5th May.
Yeah.
And it has been listed today. So let it
Ah.
come up on 5th May, Monday.
Okay. Learned counsel, Mr.
CD
name?
Rumsung for the respondent,
CD Rongsung for respondent for
for
sole,
the private respondents. Two
for the
respondents.
respondent has submitted that the matter was to be listed on 5th May and the matter may be listed on 5th May. Learned Counsel, Mr. Fullstop.
Jamir.
Jamir is present for the petitioner. List the matter on 5th May.
Obliged.
For motion, item number 1.
May I please, Your Lordship? Lordship, this is an application under section 5 of the Indian Limitation Act.
Okay, issue notice there.
Lordship,
How many days?
60 days, Lordship.
Huh?
60 days.
60 days.
Yes, Lordship.
Issue notice. Applicant to take steps to issue notice to the respondents, stroke opposite party, list the matter after 4 weeks.
Lordship.
Returnable within 4 weeks, লিখি দিবা, list the matter, list accordingly লিখি দিলে হৈ যাব।
Obliged, Lordship.
For motion, item numbers 3 and 4.
May I please, Your Lordship? This is an application under section 5 of the Indian Limitation Act 1963, Your Lordship. I'm praying for condemnation of 60 days delay, Your Lordship.
Okay,
Lordship.
learned counsel, Mr.
Medovero.
Medovero is present for the applicant, stroke appellant. Issue notice to the respondent stroke opposite parties, returnable within 4 weeks.
Lordship.
List accordingly.
Much obliged, Lordship.
Item number 2, no?
3 and 4.
Or 3 and 4, okay.
Yes.
What about 2?
1 and 2 was together.
Okay. 1, 2 একেলগে আছে দেই। MSc to একেলগে আছে। IA to MSc.
For orders, item number 7.
May I please, Your Ladyship?
Yes.
As per the honorable, this court order dated 25/3/2025, I have taken step upon respondent number 5 and 6 through paper publication on 24/4/2025. However, I'm yet to file my affidavit. If this matter may be listed after a week, I'll be filing in the course of the day. I have
Okay,
the
affidavit.
consent from the other side.
Okay, learned counsel, Mr.
James Newman,
Item number
7.
J,
James Newman, on behalf of Takakicho,
J,
AMES, NEW, MAI.
James লিখি থৈ দিয়া। James তাৰপিছত বাকিখিনি লিখি দিবা। On behalf of learned counsel,
Takakichu.
Mr. Takakichu has with the consent of the other side has submitted that he will file affidavit relating to notice published through a paper publication. List the matter after
1 week,
1 week.
much ado.
For orders, item number 8.
Item number 8 is hearing, I think.
Hearing.
Your Lordship,
Mm.
my senior has some personal difficulties, so kindly the matter may be listed after 2 weeks.
No objection, my lord.
Learned counsel, Miss,
Maungkala,
once more,
Maungkala,
Mount Pala. On behalf of learned counsel, Mr.
Sintiyangar.
Item number, what is this item number? 8, no? C? On behalf of whom?
Sintiyangar.
Sentiangar.
Yes.
Sentiangar, comma with the consent of the other side has prayed for adjournment, list the matter after 4 weeks. Did she say?
2 weeks.
2
2
weeks.
weeks, okay.
Much obliged.
Much apologies.
For hearing, item numbers 16 to 21.
May I please, Your Lordship? This read petition from item number 16 to 21 is a kind of similar prayer for minimum scale of pay. So the government has issued an OM dated 5/3/2025.
Okay,
So based on this OM, Your Lordship may please to dispose.
okay. All right.
As per the OM, Lordship, yes.
ROP 2015, Lordship. Common order or separate order?
Common order, Lordship, for all the petitions, Lordship.
Common order.
Lordship.
You just check order dated 22/2/2024. Huh? Your name?
Lilam Thong Phim Chongor.
And your name?
S. Chang.
S. Chang.
Lordship.
You start from paragraph 2. Order dated 22/2/2024, paragraph 2. Miss S. Chang. No, you don't start paragraph 2. I'll dictate it. Paragraph 1, I'll dictate. Heard learned counsel, Mr.
Lilam Thong Phim Chongor.
For the petitioner, all together, we'll pass a common order for the petition. I think we'll pass separate orders.
Lordship,
Separate
yeah,
orders will be
Lordship.
better.
Lordship.
Yes,
Be more
Lordship.
convenient.
Lordship.
But the orders will be same. Only the petitioner's names have to be changed. For the petitioner, so and so, who has filed this application under Article 226 of the Constitution of India, praying for issuance of a writ in the nature of certiorari or mandamus or any other appropriate writ or order or direction of like nature, directing the directing nalai with prayer for directing is not required. You just cut off directing with prayer for setting aside and quashing the impugned office letter dated 8/7/2021 issued by Engineering Chief, NPWD Nagaland, Kohima, and direct the state respondents to consider the case of the petitioners for granting higher scale of pay. Then order dated 22/2/2024, paragraph 3. Thereafter you insert paragraph 3. Paragraph 4 also. An affidavit in opposition was also filed by the respondents, no? Had Miss H. Chang for the respondent number?
On the 6th, Lordship, all the respondents.
For the respondent number numbers 1 to 6. The learned counsel for the petitioner has submitted a copy of the order dated 5/3/2025, copy of the office memorandum, not order dated, huh? Copy of the office memorandum number AR-3/GEN-67/2001 dated Kohima the 5th of March 2025. which reflects the order of the Chief Secretary on behalf of the Government of Nagaland that by letter number CAB-1/14/2023 dated 25/2/2025, all work charged and casual employees in all the departments, whose names have been duly verified by the district level verification committee and registered in PIMS, receiving pay shall be granted scale of pay as per the, it's okay? If you want me to go slow, then I can dictate slowly. It's okay. Scale of pay as per the revision of pay, 2015 with effect from 1/4/2025. All the departments having work charge and casual employees are directed to expedite the conversion accordingly, full stop. As the grievance of the petitioner has been addressed. Okay, it has been addressed, no? His name is within the range, within the zone.
Yes, your lordship.
As the grievance of the petitioner has been addressed, this matter stands close. You want a time period to be any direction?
Within a period of 60 days.
Lordship, if sufficient time may be granted, Lordship.
Okay.
There are so many cases.
Thereby, the respondents are directed to expedite the conversion accordingly within 3 weeks, 3 months,
Lordship, 5 months, Lordship.
to make every endeavor to make every endeavor, to expedite the conversion within 5 months.
All right,
All right, or you want shorter time?
no problem.
5
No,
months.
Lordship.
Okay.
Obliged, Lordship.
Much obliged. Your
Even the Chief Secretary also, then in terms of the above observation, this petition stands disposed of. So all the orders will be same, only you'll have to change the names, no? This office memo is marked as X and will form a part of the only one, WPC number, part of the record of WPC civil number 23 of 2024. Only one, in one record I have
Lordship.
put it. After the submissions of both the sides, you include one line. I have considered the submissions of both the sides.
Obliged, Lordship.
much obliged, your lordship.
Anything else? No.
No, ma'am.
From the supplementary cost list for hearing, item number 22.
May I please, your lordship?
Mm.
Here, the petitioner is praying for minimum scale of pay, your lordship. Here, petitioner is praying for minimum scale of pay. As per the Honorable Supreme Court judgment and order dated 26/10/2016, your lordship. The State Council is in another court, your lordship is coming. May I start, your lordship?
Yeah, you can start.
The lordship, here, the petitioner was appointed as NLC porter in a fixed pay in the year 1998. After serving for 24 years, the petitioner submitted representation for minimum scale of pay. However, the department was not considered. Therefore, the petitioner approached this honorable court in the year 2022 Now the petitioner was superannuated, Your Lordship.
Mm.
However, my prayer is to this honorable court is direct the state respondent to grant minimum scale of pay as Honorable Supreme Court order dated
Mm.
26/10/2016, Your Lordship.
Mm. Mm. The Supreme Court judgment.
Yes, Your Lordship.
Have you annexed the judgment?
Your Lordship, I have extracted in my petition
Okay.
at page 6, para 8, Your Lordship.
Page 6 para 8.
Yes, Your Lordship.
Who will reply to her?
My lord,
This is a very short submission.
yes, my lord, but she is engaged in court number 1, my lord.
Okay.
My lord, in the recently there is one office memorandum that
I
is
know.
yes, that one. But here the petitioner is retired, my lord. Yes, yes.
After retiring, I think they have a catch. I think there's a catch after retirement. So a very short submission. She wants the minimum scale of pay. I think you know about the case.
Your Lordship, here they were seeking regularization. Oh, sorry, Your Lordship, a minimum scale of pay. But since the petitioner had retired, Your Lordship, the OM which the
For who are still working.
yes, still for so this won't cover the petitioner, Your Lordship.
And the judgment of Supreme Court won't cover.
Your Lordship, it also won't cover because they have not made a specific statement regarding the responsibility and that they're
Your Lordship, I
discharging the.
stated in my affidavit in
Your Lordship,
reply.
mere affidavit would not, mere statement would not do, Your Lordship. There has to be a proof, Your Lordship. And in support of this, Lord, I have a judgment, Your Lordship. Your Lordship, if I may, Your Lordship. Your Lordship, I would like to, start from para 18, Your Lordship. I would like to rely on para 18.
Para 18 is.
Para 18. I'll be relying on a number of paras, so I'll just read out. I may be allowed to read, Your Lordship. Then. Para 18, Your Lordship. Instead of.
Yes, please.
Yes, Your Lordship. Instead of Haryana versus Jasmeer Singh, this court considered the provision of Article such and such of the Constitution and held that the principle of equal pay for equal work is not always easy to apply. There are inherent difficulties in comparing and evaluating the work done by different persons in different organizations or even in the same organizations. There may be differences in educational or technical qualification which may have a bearing on the skills which the holders bring to their job, although the designation of the job may be the same. There may also be other considerations which have relevance to efficiency in service, which may justify differences in pay scales on the basis of criteria such as experience and seniority or a need to prevent stagnation in the cadre, so that good performances can be elicited from the persons who have reached the top of the pay scale. There may be various other similar considerations which may have a bearing on efficient performance in the job. Para 19, Your Lordship. Instead of Haryana and such, the court has held under to claim a relief on the basis of equality is for the claimants to substantiate a clear-cut basis of equivalence and a resultant hostile discrimination before becoming eligible to claim rights on a par with the other groups vis-a-vis an alleged discrimination. Equal pay for equal work is a concept which requires for its applicability complete and wholesale identity between a group of employees claiming identical pay scales and the other group of employees who have already earned such pay scales. The problem about equal pay cannot always be translated into a mathematical formula. Para 20, Your Lordship. And such and such, this court considered a similar issue and observed that while determining the issue of parity in pay, large number of consideration and various dimensions of jobs are required to be taken by the courts. The accuracy required by the job and dexterity it entails may differ from job to job. It cannot be evaluated by the mere averments. This is important, Your Lordship. Mere averments in the self-serving affidavits or counter affidavits of the parties. It must be left to be evaluated and determined by expert body. The court further held as under such and such. Your Lordship, para 21, Your Lordship. In Meena Ram Kanoja versus Ames, this court dealt with an issue of pay parity between speech therapists and audiologist, and held that merely because speech therapists who perform similar duties and functions in other institutions are paid higher pay scales is no good ground to accept the petitioner's claim for equal pay. There may be differences in educational qualification, quality, and volume of work required to be performed by the hearing therapists or other institutions. The person claiming parity must sufficiently produce material before the court to adjudicate upon such a complicated issue of factual determination. More so, if the employer is not the same, the principle of equal pay for equal work would not be applicable. Para 22, Your Lordship. It is the duty of an employee seeking parity of pay under Article 39D of the Constitution of India to prove and establish that he had been discriminated against, as the question of parity has to be decided on the consideration of various facts and statutory rules, etc. The doctrine of equal pay for equal pay as enshrined under Article 39D of the Constitution, read with Article 14 thereof, cannot be applied in a vacuum. The constitutional scheme postulates equal pay for equal work for those who are equally placed in all respects. The court must consider the factors like the source and mode of requirement, appointment, the qualification, the nature of work, the value thereof, responsibilities, reliability, experience, confidentiality, functional need, etc. In other words, the equality clause can be invoked in the matter of pay scales only when the wholesale identity between the two holders of two posts. The burden of establishing right and parity in employment is only on the person claiming such right. Your Lordship, basically these propositions I like to rely. If am I allowed to read all the paras or all this?
Yeah, you can
Okay,
read
then.
if you want to,
Okay. Your
on which you are relying.
Yes, Your Lordship. And also para 26, Your Lordship. In Union of India versus SL Data versus Union of India, such and such, this court held that the determination that two posts are equal or not is a job of the expert committee, and the court should not interfere with it unless the decision of the committee is found to be unreasonable or arbitrary or made on extraneous consideration. More so, it is the executive function to fix the service condition, etc., and lies within the exclusive domain of the rule-making authority. Para 27, in such and such, this court held, in our opinion, fixing pay scales by courts by applying the principle of equal pay for equal work upsets the high constitutional principle of separation of powers between the three organs of the state. Your Lordship, and then para 28, Your Lordship. In such and such, this court held as under, it is open to the court to consider whether it is not open to the court to consider whether the equation of posts made by the central government is right or wrong. This was a matter exclusively within the province of the central government. Perhaps the only question the court can inquire into is whether the four principles cited above had been properly taken into account. This is the narrow and limited field within which the supervisory jurisdiction of the court cannot operate. 29, it is a legal settled proposition that it is not always impermissible to provide two different pay scales in the same cadre on the basis of selection based on merit with due regard to experience and seniority. No uniformities would not in all event violate Article 14. Thus, a mere difference does not always amount to discrimination. In view of the above, the law on the issue can be summarized to effect that parity of pay can be claimed by invoking the provision of Article 14 and 39D of the Constitution of India by establishing that the eligibility, modes of selection, recruitment, nature and quality work, and duties and effort, reliability, confidentiality, dexterity, functional need and responsibilities and status of both the posts are identical. The functions may be the same, but the skills and responsibilities may be really and substantially different. The other posts may not require any higher qualification, seniority, or other like factors. Granting parity in pay scale depends upon the comparative evolution of job and equation of posts. The person claiming parity must plead necessary averments and prove that all things are equal between the posts concerned. Such a complex issue cannot be adjudicated by evaluating the affidavits filed by the parties. Para 31, the onus of establishing the discrimination by the employer lies on the person claiming the parity of pay. Your Lordship, as such, Your Lordship, since the burden of establishing the right on parity is on the petitioners claiming such right, Your Lordship, in this case, this has not been done, Your Lordship. Therefore, Jagdit Singh case will not be applicable in this case, Your Lordship.
Your Lordship, I may take you to my annexure 6, page 22 in my writ petition, Your Lordship.
The moment. Which paragraph?
Your Lordship, in my writ petition annexure 6, page 22. Your Lordship, several fixed employees approached this honorable court. Accordingly, they were granted relief, Your Lordship. As per the Supreme Court judgment and order dated 10.
In your
26.
reply, no?
Not, Your Lordship, in my writ petition.
Or WPC, okay.
Annexure 6, page 22. Here, the petitioner also fixed employees. By order dated 24/9/2018, Your Lordship.
Okay.
Here, the petitioner also fixed employees. Your Lordship, however, the honorable, this writ petition is disposed of with the direction to the respondents to take a decision on the petitioner's representation for grant of minimum scale of pay as per his representation dated 10/6/2015. The entire exercise that be carried out within a period of 4 months from the date of receipt of a certified copy of this order, and the decision taken should be communicated to the petitioners. Your Lordship, accordingly, by office order dated 23rd Jan
Just a
2020,
moment,
annexure.
last order, no? Last order, 5 months from the date of receipt of certified copy of this order, you have to add, huh? I forgot to add that after dictating, okay, yes.
Your Lordship, accordingly, as per the honorable court order, the office order dated 23rd Jan 2020, all the petitioners were granted relief, Your Lordship. Therefore, same your state should apply to the same government employees, Your Lordship.
She is saying that he is retired. Are these petitioners
Your
retired?
Lordship, however, the petitioner approached this honorable court on 24/8/2022, Your Lordship, before his retirement, Your Lordship.
Okay, okay.
Before his retirement, he approached this honorable court, Your
Okay,
Lordship.
okay. You see,
Your Lordship here, but in the OIM, the policy of the government, Your Lordship, there is a time frame, Your Lordship. Time frame is given.
However,
So
Your
the
Lordship,
petitioner
prior to
retired
the,
before so we cannot go beyond this OIM, Your Lordship. Your Lordship.
Your Lordship, prior to that, when several petitioners were granted relief, Your Lordship.
But they were in service, Your Lordship. Here the circumstances have changed, Your Lordship. The petitioner has retired, Your Lordship. Your Lordship.
that same OM, no?
Oh,
That
she has
same order.
submitted, Your Lordship. Yes, Your Lordship. Since
No,
they're-
no, she has not
Okay,
submitted.
Your Lordship.
Other parties are,
Okay.
other parties have been continuously submitting
Okay, Your
this
Lordship.
OM.
Okay, so
And
I'm
the
just,
cases have been settled.
okay, I'm just bringing to your notice saying, to show that there's a time frame. So the petitioner is not covered by this OIM because before this time frame, this OIM came into play, Your Lordship, into act, the petitioner had already retired. So this will not benefit her. And as I submitted, Lord, even under Jagjit Singh, Your Lordship, in Jagjit Singh case, those parameters, the parameters given in the Jagjit Singh was satisfied, but in this case, Your Lordship, the petitioner has to prove before the court, Your Lordship, that they're performing the same responsibilities and duties, Your Lordship, which is not before the court to adjudicate today, Your Lordship. So
Okay.
on that ground, Your Lordship, I
All right.
raise my-
Your Lordship is well aware that the petitioner approached
Before
this
retirement.
honorable court, yes, before he retired, Your Lordship. And during the pendency of the case, the petitioner was retired, Your Lordship. Therefore, my prayer is to direct the state respondent to
She
grant
was
minimum scale of
appointed
pay, Your
during the
Lordship.
Pendency of the case, the petitioner.
Yes,
was
and the
retired.
petitioner has been serving the
Lordship, but,
department
the
for more
OIM
than
in the
26
OIM, Your
years, Your
Lordship, the time
Lordship.
frame is given, Your Lordship, but we cannot go beyond that, Your Lordship, beyond the OIM.
Where,
Your
where?
Lordship,
However, Your Lordship, the Honorable Supreme
I
Court
may be allowed
judgment
to
is
read
clearly
it.
stating that principle of equal pay for equal work,
But
as Your
for that,
Lordship
Lord,
is
she has
well
to
aware.
satisfy the court that the parameters given in the Jagdish Singh has to be
Dipandu
satisfied.
Bhattacharya's case.
In Jagdish Singh's case, Your Lordship.
Okay.
Yeah, Your Lordship. And Your Lordship, with regard to time frame, Your Lordship, I may be allowed to read from the OIM, Your Lordship.
Yeah, sure.
Your Lordship. On the recommendation, this is an OIM dated 5th March 2025. Subject conversion of work charge, wages of work charge and casual employees to scale pay as per revision of pay 2015. On recommendation of the Nagaland Work Charge and Casual Employee Decision conveyed via letter such and such, 25th February 25, all work charge and casual employees in all the department whose name have been verification committee and registered in PIMS receiving fixed pay shall be granted scale of pay as per the revision
His
of
name has to be registered in PIMS.
Yes, Your
Lordship. This is the time frame, Your Lordship.
Oh, with effect from one.
Yes.
However, Your Lordship, my prayer to this honorable court is that the existing case is clearly stating that the principle of equal pay for equal work, Your Lordship.
But for that, she has to satisfy the court, Your Lordship, that she falls under those parameters prescribed in
And the petitioner has been
justice.
sincerely working with it, has been serving the department with full sincerity, Your Lordship, like any other regular employees, Your Lordship, during his energetic days.
When did he retire?
Your Lordship, it was last month, 9 of March 2025, Your Lordship.
I don't know. I'll have to ponder over it. I'll reserve it for judgment and order.
Your Lordship. Your Lordship, may I place the appeal order dated 10/8/2022, Your Lordship. Also, the SLP order dated 24/9/2024, Your Lordship.
Your Lordship, if I may, Your Lordship, after this, the orders which has been placed by the petitioner, the government has framed the policy prescribing this thing, scale pay to the fixed pay
Yes,
employees.
yes.
But she's not covered by that, Your Lordship.
Looks like.
Yes, Your Lordship. And as per Jagjit Singh also, as I've submitted the like, Supreme Court citation, Your Lordship.
Okay, I'll go through the High Court judgment also, no?
Your Lordship.
Supreme Court judgment, High Court judgment, for petitioner you have submitted, no?
Your Lordship.
Hard miss,
H. Liang, Your Lordship.
A,
H. Liang.
learned counsel for the petitioner and Miss Inwala, no?
Inaholi.
Inwala,
Inaholi.
Inaholi. So I have disfigured your name.
It's all I realize.
Miss Inaholi for the government, no?
Yes, Your Lordship.
For the respondent, all the
All
respondents.
the respondents, Your Lordship.
How many respondents?
Your Lordship,
You'll have to pin this up, huh?
1 to 7, Your Lordship. Oh, 1 to 8.
Respondents number 1 to 8, list reserved for judgment and order.
Your Lordship, I may place the Honorable Court order judgment dated, common order judgment dated 10/8/2022, single bench order judgment.
I'll go through each and every point you have made.
Your Lordship.
This has to be fixed here so that it won't disappear from the record.
Take your.
Pin it up, huh? Okay. Matter over?
Your Lordship, on the similar ground, this order has been passed.
Okay,
Through Your Lordship.
sure.
Same facts, or not exactly the same facts, but
Okay. If I can pass an order within these 2 days, I'll pass it because I think the order has to be prompt. I
Yes,
should
Your
not
Lordship.
keep it pending for 3 months.
Yes, Your
It has
Lordship.
to be prompt, I think,
Yes, Your Lordship.
because he's also a retired person.
Yes, Your Lordship. And Your Lordship is well aware that he has been serving the department for more than 27 years, Your Lordship, during his
I'll
energetic
try to
days, Your
pass
Lordship.
this order within very shortly. This is not a big, massive case.
yes, Lordship.
Within 1-2 weeks, I'll try to pass because I do not have much time also today. And she's also alone today. petition.